is the constable. Police constable, Your Lordship.
Yes.
Now, I want to state before Your Lordship, the huge amount were taken from the de facto complainant. It's okay in one part. And the second part is that a huge amount has been refunded from the several other persons also. There, bank statements there, 164 statements are there.
No, we are concerned with this case. Okay. So
They are interconnected. They are the relative of the complainant.
Case was started under many sections,
What is sections?
including 419, 420, 406, 409, 120B of the Indian Penal Code, 7 and 13 of the Prevention of Corruption Act. And now the charges have all carteled down to only 419 and 420 of the Indian Penal Code and sections 7 and 13 1B of the Prevention of Corruption Act. That is, if the charges are somehow even proved, the maximum punishment can be of 5 years for the Prevention of Corruption Act. The allegation is that the complainant,
are in custody.
I am in custody for 1 year and 7 months. Why I am removed for bail? I'll submit only 2 points. The complainants alleged that her father has given the petitioner a sum of rupees 30 lakh to aid her in getting the bar license. That time, the petitioner being a police personnel said that he has connections with higher authorities and he will help him in getting the bar license. He took 30 lakhs. The petitioner was first arrested on 17th of May 2023. Thereafter, on 18th of November 2023, the petitioner was released on interim bail by the jurisdictional court till 14th of December 2023. That on condition that he should repay 50% of the alleged misappropriated sum within 14th of December 2023. The petitioner failed to do so. He was again taken back into custody on 14th of December 2023. Till that time, he is in custody. After his rearrest on 14th of December 2023, the petitioner prayed for bail before this honorable court. That is at page 26. When this honorable court was pleased to reject the petitioner's prayer for bail, and if your lordship kindly comes to paragraph 5 at page 27, this honorable court directed that the learned trial court to expedite the trial to the fullest extent possible and conclude the same at an early date, positively within a period of 1 year from the next date and of recording of the evidence. This order was passed on 21st of August 2024. Now, thereafter, what has happened, the changed circumstance, page 15, if your lordship kindly sees, right now the petitioner's wife has been diagnosed with cancer. The petitioner's wife has given a demand draft of rupees 15 lakh that was accepted by the de facto complainant. That is at page 15 and 16. That was for 15 lakhs. And rest 15 lakh, the wife of the petitioner, who is a cancer patient, has given by way of a post-dated check. The checks are dated of 31st of August 2025 of the rest 15 lakh. That is at page 17. After having this 15 lakh in demand draft and the post-dated check of the rest 15 lakh.
15 lakh demand draft was received.
Received.
And post-dated check is
15 lakh. Another 31st August 2025 by my wife. Now, my lord, if your lordship kindly comes to the last page of the petition, the very last page. The very last page of the brief, the annexure, the certified copy. That is the affidavit which has been, this is the page, my lord, the affidavit page. The last page of the certified copy, my lord. The de facto complainant has made an affidavit before the concerned jurisdictional court that if the petitioner is released on bail, she has got no objection. Such no objection was also recorded. If your lordship kindly comes to the order dated 30th December 2025, order number 41.
yes.
There also the de facto complainant has stated that she has got no objection if the petitioner is granted bail. Now, till the time my prayer for bail was rejected, till now, W1 has been examined out of 12 witnesses. Charges were framed on 23rd of April 2024. My lord, admittedly,
Okay, it was rejected on 7/5.
7/5
Bail petition was rejected.
by the concerned jurisdictional court. My lord, concerned jurisdictional court, it was rejected. Now, my lord, now admitted position is that out of the 30 lakh that was alleged to have been received by me, 15 lakh has already been given. My wife has been diagnosed. Excellent. My wife has been diagnosed with cancer. She has given a post-dated check of 15 lakh more. If the charges are somehow been proved, my punishment will not, will be till 5 years, which can extend to 5 years because the charges are now only under 419, 420 and 7 and 13 of the Prevention of Corruptions Act. Now, my lord, what I am humbly praying, if your lordship kindly consider that I am in now custody for 1 year, 7 months. My lord, 50% of the sum has been paid already. My lord, this is the condition if your lordship kindly considers.
Yes.
Lordship, by an order dated 3/7/2023, this matter got transferred from investigation from Newtown PS to CID. CID have investigated this matter. Now, your Lordship, the petitioner is the constable. Please, constable, your Lordship.
Yes.
Now, I want to state before your Lordship, the huge amount were taken from the de facto complainant. It's okay in one part. And the second part is that a huge amount has been refunded from the several other persons also. There are statements there, bank statements there, 164 statements are there.
No, we are concerned with this case. Okay. So
They are interconnected. They are the relative of the complainant.
no.
They are known person of the complainant.
No, so far the other persons are concerned. If there are other cases instituted, those cases will continue. So for this case, the trial is going on.
This case,
Yes, so-
evidence of the complainant not completed yet.
Evidence of the complainant not complete.
Not completed.
How many witnesses to be examined?
12.
12. And maximum years of punishment in prevention of corruption?
5 years.
5 years.
And I am in custody for 1 year, 7 months from December, and before that, I have already been in custody for 5 more months.
He is,
406.
My lord, 419, 420 charges framed under sections 419, 420 and 7 and 13, 1B of the Prevention of
if
Corruption.
you Lordship kindly see the bank statement of the petitioner, huge amount has been credited.
Madam,
He is a constable. From where he is getting
Madam,
huge amount?
2
Lakh rupees, 68 lakh has been credited
My lord,
in his account.
more than 2 years, my
But then
lord,
he is
suffered
getting all this account.
incarceration.
He is defrauding everybody.
My lord, more than
Prevention of Corruption Act is there.
My lord, more than 2 years, I have suffered the incarceration.
This person,
I have
this
been
company is related in huge other persons are also related in this. And 15 lakh he has, is okay, he has, by check he has given. And what about the other
check, by
15?
demand draft.
By demand draft. What about the other 15 lakh? He won't pay, I know that, because he has defrauded other many persons.
My lord,
He is a habitual offender.
my lord, if that post-dated checks get bounced, my lord, they will again file 138 against my wife.
And Lordship,
That is a undertaking, my lord, by the wife. She is a cancer patient. I have annexed the documents also.
and there is one person,
This case-
Rizwan,
Case
Lordship,
ID is which
there is
one?
one-
This is 24/2023.
there's a settlement,
Okay, the same case ID.
Yes.
same case.
And my lord,
Peter case, part 2. Lordship, there is one person, Rizwan Ahmed, you have completed your submission, please let me give.
Yes.
There is a
I have
person, Rizwan Ahmed, he is related to this person, petitioner. In his account, 48 lakh rupees, this petitioner has credited. From where he is getting all this money? Being a constable? No, 30 lakh is not the factor here.
That is sections 7 and 13.
7 and 30.
7 and 13 of the Prevention of Corruption Act,
Case that you have 6,000 cases.
punishment is from 3 months to 5 years.
419 and 420.
419, 420 charges are only
Evidence of the victim not completed yet.
Learned advocate for the petitioner and learned advocate for the state are present. Learned advocates for the parties produce the materials in the case diary. Learned advocate for the
Not this stage, Your Lordship.
submits that the petitioner is in custody for 1 year, 8 months. And earlier the petitioner was granted interim bail.
My lord, more than 2 years, because earlier I was in
Not more than 2
custody.
years. 759 days.
Earlier the petitioner obtained interim bail, but
I'm sorry.
as he could not make payments to the de facto complainant, his interim bail was cancelled. It is further submitted by the learned advocate that earlier the petitioner was implicated under different sections of the Indian Penal Code, but the charge sheet is submitted under section 419, 420, section 7 and section 13. 419,
Exit fixed on 25th
420 of
June.
the Indian Penal Code. and Section 7 and Section 13 of the Prevention of
Article
Corruption Act
50.
1988.
No, my lord. Charges were framed under those sections.
Okay, charge.
Charge sheet was under many sections. Charge sheet was under section 419, 420, 406, 409, all.
But charge was submitted.
Charge was framed on
Framed
under
under
section
Section 419, 420 and Section 7,
23/4/24 অর্ডারটা দেখো
13 of the Prevention of Corruption Act. তাহলে 419
Under section 406, 409, 419, 420
charges framed
490
charges.
490
charges date হচ্ছে
420 of IPC.
23/4 charges
charges
And Section 13 of Prevention PC Act 1988.
জানি আমি
Learned advocate
এখানে
draws
লিখতে হবে।
attention draft of rupees 15 lakh already issued to the de facto complainant by the wife of the petitioner and a post-dated check. Learned advocate submits that the wife of the petitioner is suffering from cancer, and considering the part payment made and the period of detention, the prayer of the petitioner for bail be considered. Learned advocate for the opposite party state objects the grant of bail and submits that the bank account of the petitioner will show receipt of different
না ওর নাম দিতে পারো না
amounts from different persons, and this aspect is also to be investigated. Upon perusing the materials of the case diary in connection with this case, and upon considering the period of detention with regard to 1 year, 8 months, although the trial has already started and de facto complainant partly examined, it would not be proper to observe anything with regard to the merits of the case, but it is necessary to consider as to whether the petitioner should be granted bail. In order to consider as to whether the petitioner should be granted bail, it is necessary to consider some judicial pronouncements. এবারে প্রথম থেকে ওটা দিয়ে দেবেন, ঠিক আছে? এই জায়গা থেকে অরবিন্দ থেকে না, সবটা না, কিন্তু ওই অরবিন্দ থেকে যে টিক মার্কারটা আছে, হ্যাঁ ওই অবধি, তারপর পরের আর একটা আছে, ব্যাস ওইটুকুই।
হ্যাঁ
Upon considering the facts of the case and the period of detention, which is 1 year, 8 months, and the fact that the case involves examination of 12 witnesses, and at present, the examination of one witness is also not complete, and there may be a delay in the trial. In the interest of justice, the petitioner should be granted bail. I therefore allow the prayer for bail made by the petitioner. The petitioner be released on bail with two sureties of rupees 10,000, one of which must be local, subject to the satisfaction of the learned trial court. The petitioner, upon being released, shall attend court on all dates fixed, and shall not meet the witnesses of this case, and shall not do anything prejudicial to trial.
I'm grateful to you.
No,